The April 13th Panama City Planning Meeting is now in order. Please take the roll.
Board Member Anderson.
Present.
Board Member Cherry.
Present.
Board Member Barker.
Here.
Board Member Rich.
Here.
Chairman Newbauer.
Here. Are there any changes or deletions to the agenda?
Mr. Chairman, there are no changes or deletions to the agenda. I did just want to point out for the record, we were handing out some hard copies for 407 Maple Avenue. That would be the item 6G, and there was public comment provided to you earlier as well. You'll see that at your seats for the yacht club items. Those are going to be items 6E and 6F. I just wanted to make sure that was stated for the record.
Are you
Okay.
referring to this?
Yes, ma'am.
Thank you. Are there any announcements or disclosures? I'll make one of my own. I am the current Commodore of the Sandy Bay Yacht Club. I don't have any fiduciary interest in any other class of membership of the yacht club, so I'm free to participate per council. So, any other? All right. Do I have a motion to approve the minutes from the March 9th Planning Board meeting?
Motion to approve.
Second.
Motion second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
Yes.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
Yes. All right, I'll now read the procedure which the board will follow for quasi-judicial hearings. 1, public hearing announced, introduction of application by staff. 2, ex parte communication disclosure by board members. 3, identification of applicant and affected parties that intend to participate in the hearing. Affected parties that only intend to make a statement may do so at the public participation part of the agenda. An affected party means any person or entity will suffer an adverse effect to an interest protected or furthered by the ELDC, including interests related to health and safety, police and fire protection service systems, densities or intensities of development, transportation facilities, healthcare facilities, equipment or services, and environmental and natural resources. The alleged adverse interest may be shared in common with other members of the community at large, but must exceed in degree the general interest and community good shared by all persons. Now I'll turn it over to council to swear witnesses.
Good afternoon. If you are here to speak on any item today, the only item that is not quasi-judicial is going to be item E. So if you're here on any other matter, please stand now and raise your right hand if you intend to speak. Mr. Herring? Do you solemnly swear or affirm the testimony you'll give in these matters to be the truth, the whole truth, and nothing but the truth? Yes, sir. All right. When you come to the podium, when your item is announced, if you'd please state your name and address for the record, and that you have been sworn.
Thank you. We'll now begin with request A.
Request A, case number PLN-2026-0756. It is a variance. The applicant is requesting a variance from the setback regulations established by section 104-26, residential 1 zoning district. The setback, they're requesting a 3-foot rear setback instead of the minimum 20-foot, and a 5-foot side setback instead of the minimum 7-foot. The owner and the applicant is Herring Companies Incorporated. Address is 616 East 4th Court, and the staff recommends approval.
Thank you. Are there any questions from board for staff?
I have questions. I went and saw it, and I wasn't sure in this property where it looks like there's 2 lots that's being proposed, and this one home is on 2 lots. So is that 2 lots inside where it's vacant, and inside there's a fence? And then there's another cleared lot. So I wasn't sure where, when you look at the fence line, if it's outside of this property or inside this property?
Good question. It's inside. So there's 2 homes.
So wait, please, yeah. This is for staff, and then we'll call you up when it's.
You look at me, so I didn't.
Yeah, sure.
It was, it's one lot with 2 homes on it. They were separated by the fence, but they plan on demoing the fence and existing shed that's there. But for further information, I defer to the applicant.
So the fence will go down,
That's what they have in the notes, yes, ma'am.
and so the 2 empty lots are either side of the fence?
Yeah,
With the
it's one-
sheds in the back on one lot?
Yeah, it's one lot, two homes.
Okay.
Being proposed?
No, the 2 homes exist and it's one lot already.
applicant cleared up. Is there any other questions for staff?
Would this affect only the existing structures, or does it also apply to any new structures?
I would believe it would only exist to the one existing structure.
Okay.
Any other questions? All right, is the applicant here to speak on this item?
Yeah.
Please come to the podium and state your name.
This is my first run at this. Yeah.
All right. So I bought this property back in August, and I guess in 1958, when the.
Name and address for the record, have you been sworn?
Okay, yes. Yeah.
Your name and address,
My address, 616 East Fourth Court,
and your name?
Mike Herring.
Very good.
All right, cool.
Pass
All
this
right,
on.
so that's very formal. So, okay, so when I bought the property in August, I didn't realize that when the houses were originally built in 1958, it was a 5-foot setback. So, we needed additional 50 square feet on the existing home on the right, which is number 610, to put in a laundry room. And it's 13 by 4, roughly, 14 by 4. So, in order to do that, I had to apply for the variance. So the laundry room is not gonna be that large, but to answer your question, it will be on the interior of the lot, not on the lot lines, not on the exterior. That answered the question.
Are there any other questions from the applicant? All right, thank you.
All right,
Is
thank
anyone else here to speak on this item? All right. Seeing none, do I have a motion?
Motion to approve.
I'll second.
Motion second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
No.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
Yes,
Motion passes 4-1.
thank you. Request letter B.
Request B is case number ending in 0794. The applicant is requesting a variance from the setback regulations established by section 104-36.3 for neighborhood residential zoning district. The applicant is requesting a 45-foot front setback instead of the maximum front setback of 20 feet. The owner is Michael Mitchell. The applicant is Kevin Downing, and it's located at 1606 and 1608 East 9th Street.
Thank you. Are there any questions from the board for staff?
I have a question. When I went and saw this property, it looks like the home is, been roughed in. It's got the plumbing, all in it. It's got the framing where the concrete would go. So my question is probably for staff, how did we get here? What's the process that somebody would have been able to have the framing where the concrete's gonna go and have it all plumbed and then get to us?
That's a good question. So a development order, no building permit has been issued for this at this time. The applicant actually started construction without those necessary approvals from the city.
Okay, so does this applicant have a contractor, or is this applicant building his or her
I
own
believe
home?
he has a contractor.
So where's the disconnect? How were they able to get this far, in other words?
Sorry, how are they able to get this far?
Yeah, why are we getting an approval for a variance for, it's already been roughed and it's been plumbed and everything?
That might be a good question for the applicant.
Okay,
Yes.
okay.
Any other questions? All right, is the applicant here to speak on this item? Please state your name and address for the record, if whether you're sworn in.
Kevin Downing, 120 Royal Palm Boulevard, Panama City Beach, and yes, I am sworn in.
Okay, thank you.
To answer your question, ma'am, it was a miscommunication between my subcontractors and myself. I
And
said,
what role do you represent?
I'm the contractor.
You're the contractor, okay,
Yes, ma'am.
thank you.
So I said, guys, we have to hold off for the variance to go 45 feet and back to where, and so they heard 45 feet, didn't hear, hold off for the variance. And so I didn't visit the site. There's no house. The plumbing, so once we did visit it, he said, hey, what are they doing? I went over there, said, stop, what are you doing? So it looks roughed in. It still has to kind of be done over again because we stopped it. So it was just a miscommunication. Told them to stop it. We have to wait for this day. And they just kept going, misunderstood what I was telling them about a variance.
So when you were planning and doing your due diligence to build this home, was it designed where it is now? And did that go to the building department and or the planning department as it exists now?
Yes, ma'am. It did go through both. And we had, like this gentleman said, we have a permit, but we had to stop.
It sounds like it was after the actual,
Yeah.
somebody,
We had not
representing
issued
the
a development
contractor.
order.
No, we had not issued a development order on this
So-
project.
So you've not issued a development
We have
order.
not.
Yeah.
No.
So that's a real problem, right?
Correct.
Yes.
Like, you're not supposed to build homes.
It's just
Without the
dirt
right-
and pipe right now. We didn't
with-
go any digging or nothing. They brought dirt in and they put up what's called batter boards around it. It can be moved within a matter of hours. So that's why I said just leave it there.
I mean, the risk is on their end. If they build it in the wrong spot and then we don't approve it, then they would have to move whatever's there and face whatever consequences. That would be the case, right, Mike?
That's right.
Okay.
Or that Mike.
No, either one.
Which Mike? Either one.
So 45 is a lot. I mean, this is in the Millville neighborhood planning area. I mean, great work has been with community engagement, and lots of thinking went into designing what should be applicable and moving forward with the Millville community. And so to say, okay, well, you can have 45 feet, that's a lot.
It's actually 25 feet because we're going from 20 feet where you're allowed, that's our max. We want to move it back 25 feet. His lot is over 210 feet deep. And he's one of the last two buildable lots. So this policy went in after all these homes were built.
Right.
So you don't see them all fronting, when the, looking down the street, door to door to door. So
Mhm.
it's kind of a little bit late, and that's why we're asking. I mean, if it was current and they were all nice and even, I wouldn't be here.
Yeah, none of the neighbors' houses are anywhere near the new setback on that.
Correct, sir.
They're all pretty close to what yours is. Do you know how many feet past the neighbor to the east that you guys are starting yours? I think it was somewhere in between
it was-
0 and 5 feet.
Yeah, it was about 7 feet, just so bathroom windows didn't line up and back decks didn't line up, so you could sit on your deck and not see your neighbor straight across.
Okay.
And if you go the other way, they're even further back.
So
Yeah,
is
question.
it the planning department's intention to issue a development order for this?
If a variance is granted, then
If a
yes.
variance is granted, yes, okay. So if a variance is not granted, then,
They would have to amend their site plan to comply with the
Yeah.
setback standards in the neighborhood zoning.
okay.
Thank you.
Can I say something?
Sure. Just say your name and address for the record and say whether you can swear in.
Michael Mitchell, 1606 and 1608 East Ninth Street. I'm the owner of the property. And what happened was I was given some advice, not by him, that you can start bringing in this till you get your first inspection. And once we put the development plan in, we didn't know about the setback until we got feedback from y'all department. However, I own all that property right there. My uncle stay right here. So I got it even with his house and the next house. There's only 2 houses on that block. And then I own all the other lots right there. So that's why I applied for this variance. I didn't want to be sitting close up here, and I got all of this land right here, that if I can at least get even with them, instead of sitting ahead of them. And that's why we stopped, whatever it is. I can get a backhoe and dig that up in 5 minutes.
Yeah, it can all be moved within a day. There's nothing permanent.
yeah, it looked like it was consistent with the other homes.
Yes.
It is. It's within a few feet of it, and
Thank you, gentlemen. Is there anyone else here to speak on this item? All right, seeing none, do I have a motion?
Motion to approve.
Motion second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
Yes.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
Yes,
Motion passes 5-0.
thank you. Request letter C.
Case number C is item ending in 0875. It is an application type for a variance. The applicant is requesting a variance from the setback regulations established by section 104-36.3 of the Neighborhood Residential Zoning District. The applicant is requesting a 30-foot front setback instead of the maximum front setback requirement of 20 feet. The owner and applicant is Beverly Jones, and the property is located at 2204 East 8th Street.
Thank you. Are there any questions from the board for the staff?
This is just to correct a nonconformity.
Yes, the applicant came in to actually return the combined parcel to its original lots of record, and it's not meeting the current zoning regulations, and so they'd have to get the variance approved prior.
Okay.
Any other questions? Is the applicant here to speak on this item?
Chairman, I had a question.
From staff or applicant?
Probably staff.
Okay. Go ahead. We'll bring her up. We can ask her about it.
Okay.
Thanks. Please state your name and address for the record and whether you've been sworn in, please.
Hello, my name is Beverly Jones. My address is 1620 Lincoln Avenue. I have my son Marcus Jones here with me. He handles most of my business as far as this house concerns.
Okay.
So-
And have you been sworn in?
Were you sworn in earlier?
No,
Would you raise your right hand for us, please?
yes,
Are you going to speak too, sir?
yes,
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
I did.
Thank you very much.
Thank you. I think we have a question for you and/or for staff.
Yeah, so when I went by this property, it looked like it was a relatively new home. And so it's kind of the same question, how did we get here that a home is actually built? And now it's coming for a variance.
I think here in Savannah, you can correct me if I'm wrong, they're trying to take the lots back to the original lots of record, which means they're trying to split it?
Yes.
Okay, so when somebody wants to come in and split the lot and they're not able to satisfy the setback requirements, obviously, we're not gonna make them tear down the home or,
Right.
modify the home. So the next best route is a variance. So that is the approach that we take when people want to split a lot and they're not able to satisfy the setbacks. We take them through the variance process. So that's ultimately why they're here today. So yes, the home was built and at the time it was in compliance. And then now they want to go back and take it back to lots of record. So that is the way we remedy that.
Okay. Thank you.
Any other questions? Applicant? Thank you.
Thank you.
Is there anyone else here to speak on this item? Seeing none, do I have a motion?
Motion approved.
Motion and second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
Yes.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
Yes,
Motion passes 5-0.
thank you. Request letter D.
Request D is case number ending in 0716. The applicant is requesting a variance from the setback regulations established in section 104-36.3 for neighborhood residential. The applicant is requesting a 26-foot front setback instead of the maximum front setback requirement of 20 feet. The owner and applicant is Thomas Zolo, and it's located at 1210 Clay Avenue.
Thank you. Are there any questions from the board for staff?
Is the intent to match the existing existing structure that's on the one parcel with another building? Is that the intent?
I think the home's already existing. It's kind of similar to the last request. They're trying to split the lot, but they need to come into conformance first.
Yeah, I guess I was asking, are they intending to build another house on the other lot? And that way they keep them the
I
same?
believe so, but we haven't received any plans for a single family. It was just a lot split request, and they weren't meeting the front setback anymore because of the rezoning.
Thank you.
That would apply to the other lot as well if we split it that way.
Yeah, did they have to come for a variance for the second lot once it's split with the county, or is it the variance?
I believe it stays with the parcel ID.
I'm sorry, I didn't.
So if they're splitting the lot, does the variance just apply to the existing home, or would they have to come to get a second variance for the new lot if they wanted to just,
If they can't build it within the parameters of the lot,
they
then
would have
yes,
to
they
come
would
back to us for a
yes.
second variance?
Yeah, this one only relates to the, what
Existing
is the lot 15 parcel.
Okay.
It's an older home. No, it's been there for a long time.
I think that one's been there for a while.
Is the applicant here to speak on this item? Please state your name and address for the record, and
I'm Don Giles, 302 Wood Trail, Panama City. I've been sworn in.
thank you.
Thomas Zolo, 1210 Clay Avenue, and I've been sworn in.
Thank you. Does anyone have questions for the applicant? That was easy. You got off the hook easy, so. Thank you. Is there anyone else here to speak on this item? Please, do I have a motion?
Just so I'm clear, when we do that, the lot split is going to be in our zoning. Okay?
Correct.
From now, okay, just checking.
And applicable to the only one lot.
Yes.
Right, they would have to come
I'm
back
just
for a
making sure I
variance
was
for
clear
a
on
second,
that.
if there are any changes in the second one.
Right.
All right, do I have a motion?
Motion to approve.
Second.
A motion second, please take roll.
Board Member Anderson?
Yes.
Board Member Cherry?
Yes.
Board Member Barker?
Yes.
Board Member Rich?
Yes.
Chairman Newbauer?
Yes.
Motion passes 5-0.
Request letter E.
This is case number CPC PLN 2026-0830. It is a development agreement with the San Andrews Bay Yacht Club and Bunkers Point Educational Foundation concerning the properties at 218 Bunkers Cove Road and 212 Bunkers Cove Road. The yacht club seeks to enter into a development agreement with the city for a 30-year term. Staff has reviewed the proposed agreement and find that it meets the statutory requirements in section 163-3227 of the Florida statutes and section 102-35 of the Panama City Unified Land Development Code. Staff also finds that the proposed agreement is consistent with section 114-3 of the Panama City Land Development Code concerning historical, non-conforming waterfront development. The primary purpose of the development agreement is to establish the manner in which the yacht club will be redeveloped and even how aspects of the yacht club will be operated in the future. With regards to vehicle parking, boat trailer parking, operation of the sailing center, and even expansions, if allowed, of docks and the boat ramp in the future. I know there's a lot of moving parts of this. This was actually before this board several months ago, and we're coming back now that the yacht club has had an opportunity to engage with the neighbors on a number of items. I think one of them was the location of the pool. If you notice in the site plan that's attached to the development agreement, the pool, which was previously proposed to be located near the sailing center, is now going to be back on the west or northwest side of the property, similar in location to where it is to this today, but a little bit farther back from the road. I think there's some other changes with allowable parking and hours of parking. I believe, unless y'all have any questions for staff, that we have several people prepared to give a presentation and also update you on the latest changes to the development agreement.
Thank you. Are there any questions for staff before we ask the applicant to come forward? All right. Is the applicant here to speak on this item?
Good afternoon. My name is Michael Wynn, 203 South Cove Lane, Panama City, Florida, and I have been sworn in. I think Mr. Fuller did an excellent job of outlining where a number of my items are on this. When we were last before this board, there were issues that really centered on the core question of whether or not what the yacht club was attempting to do following the destruction of its facility in 2023 by fire was going to expand the burden upon the neighborhood in a manner that violated its status under the ULDC and incorporated ordinances. What we have here today and what I'm going to go through with you all as it relates to the development agreement is what I think is the fruition of a substantial amount of communication, hard work on the part of a lot of the parties who are seated here today, in an effort to allow for the yacht club to be able to be a good neighbor and a continuing amenity for this community, while not affecting its neighbors in a detrimental manner. I'm proud to say that I believe that we have achieved that consensus today. And what I'd like to be able to do is walk you all through some of the changes that were necessary to the development agreement in order to reach what we believe that consensus to be. Unfortunately, due to a printing issue at my office, I was unable to have individual copies. However, I have lovely pink tabs and would love to walk you guys through some of the changes to the development agreement and put them on the record so that way everybody understands what we're trying to do to move forward. So for those of you who have the development agreement in front of you, one of the first changes occurs at page...
Mr. Nguyen, real quick.
Yes, sir.
When
Mr.
you
Burke.
say the development agreement in front of you, you mean the one that was published with the
Yes, sir,
agenda?
that's correct.
Okay.
What I have done is created a red line against the published development agreement that incorporates a number of changes that were made that address what I would describe as minor tweaks to make sure that the language of the development agreement adequately reflects the negotiations of the parties involved.
Okay, just so all the board members are clear, there have been some ongoing changes even up until the last few hours. So what Mr. Nguyen is about to walk you through are some changes that are compared against what you've got. It's going to be different than what's in front of you. So we need to listen to that, and then if we can get some copies, we'll get some done real quick. But in order not to delay us, I'm going to let Mr. Nguyen go ahead, if that's all right with the board.
In what document that we have that are you going to be referring to?
Yes, ma'am. You should have a document that's entitled Sandrews Bay Yacht Club Development Agreement. That begins with the development agreement is entered into this day.
Okay.
Yes, ma'am. Oh, yes, ma'am. Absolutely. So the first change, any other questions before I move through the document?
State the page that you're doing.
Yes, sir. First change occurs on page 3. The section begins with, whereas subsequent to, and previously it said occasion, the word occasion will be stricken and stated, whereas subsequent to the occasions described above, the owner has and continues to make a good faith and successful effort to minimize any increase in the burden caused by the sailing center as a temporary clubhouse only during the design, permitting, and construction of the new clubhouse. The reason for that change, for purposes of the board's understanding, is to acknowledge the fact that the yacht club has, from time to time, not been the world's best neighbor, and it has imposed, from time to time, a burden on its neighbors, and we're trying to commemorate that and acknowledge the changes we're making to address what has occurred in the past. The next change occurs on page 4. This is a small change. You'll note where it says now, comma, therefore. What we did is we, instead of bunkers being possessive, bunkers is, we removed the apostrophe there, but wanted to clear that up. The next changes occur on page 5. Little letter C, you'll see where I believe in your document it says Boyle parcel. We've added the addition of or Boyle property to avoid any potential confusion. Moving along, on page 6, what will now become little letter Y is a new section entitled Special Event. A special event shall be defined as a discrete occasional event that is not part of the property's regular day-to-day operations. Special events are distinct from routine recurring club activity and are subject to the additional operational limitations set forth in this agreement. The next portion underneath there will be little letters AA. Much like with the Boyle property, this would be to reference Stokes parcel as you see it, to now include Stokes parcel or Stokes property. Moving along to page 11, the section number 5 is entitled Sidewalks. There was, you'll note that the provision reads, "There's currently no sidewalk along the Yacht Club side of Bunkers Cove Road, and the city is not requiring the owner to construct a sidewalk as a condition of redevelopment. The city reserves the right in its sole discretion and at its own expense to construct a public sidewalk within Bunkers Cove Road right-of-way in the future, but neither the owner nor Bunkers Point or its successors shall be obligated to install, or pay for any such sidewalk." The word "not" was inadvertently put in there, which creates a double negative. The word "not" is being stricken from that paragraph. Moving along to page 14, subsection 3, which I think is where a lot of our final comments are going to come from. Underneath Stokes parcel limitations, some of you may have heard us reference this as the Sailing Center property, also known as the Stokes parcel. Your document contains a subsection A under 3, as well as a subsection B. Subsection A is entitled No Expansion. Subsection B is entitled Zoning Status of Sailing Center. What we realize is that these two provisions become largely duplicitous, and so we have stricken the language of subsection A and included A and B together to create new letter A, which would be No Expansion and Zoning Status of Sailing Center, and it covers them both in one paragraph. The next page we're going to move to is page 15, Impervious Surface. Impervious surface will be edited to read as follows. No additional impervious surface or semi-impervious surface, including but not limited to asphalt, concrete, crushed concrete, gravel, shell, or similar aggregate, collectively referred to as aggregate, shall be installed on the Stokes parcel except where reasonably necessary for safe ingress, egress, or code-related accessibility of the sailing center. No parking areas, storage, or expanded use areas shall be created through the use of aggregate. This shall not prohibit addition of the word occasional overflow vehicle parking on grass and sand. So as you'll see, what we did is we struck out the language beginning with portion and concluding with Exhibit C in that section. Moving along to page 17, under penalty for extended overnight parking and towing. What I'm going to do is read the language as it will now be redrafted. You'll have to forgive me, my ink really started kicking out here. It says, if a rig remains on the Stoke parcel longer than 2 consecutive nights, the owner shall charge the associated member nightly a fee comparable to fees charged by private parking facilities and collectible in the same manner as fees of club services and dues, and 2, use reasonable commercial efforts to contact the associated member to seek removal, adding the language, within 24 hours. If the owner, if after adding the language 72 hours, the rig is not removed, the owner shall, adding the language, make all reasonable efforts to have it commercially towed in the associated member's expense, subject to compliance with any applicable legal requirements for towing. Moving down to subparagraph 6, during regattas or adding the word special event is the change that occurs there. Coming along on page 18, there was a duplicitous heading under Sailing Center Restoration Limitations. We have stricken the duplication. Under subpara D, there is the addition of little 3 I's, and it shall say, in no event shall temporary facilities be used to expand operational capacities or intensity. Moving along to page 20, events during reconstruction. Under, again, that's section G on page 20. Going to read, let's see here, it starts with the word in addition on the 4th line. In addition, striking the language any portion of, so it should read, in addition, an event occurring after 9:30 p.m. and before 8 a.m. shall be confined to the interior of an enclosed permanent structure or enclosed temporary facility under the interim operations plan. The next section in change occurs under Section 6, Local Laws and Policies. On the, what I would call the second to last line, it should read, following the word that says agreement, we have added the addition, subject to all limitations, restrictions, and conditions set forth herein. Moving along to duration of vested rights on page 22. There's, I believe it's the third, make that fourth line from the bottom there. It should say, however, all improvements, adding the word lawfully constructed pursuant to this agreement. And then lastly, the two provisions that would be added at the end of the document would be, which would begin on page 23, I believe, of your docket, would have little letter H, which would state intent. This agreement is intended to define but not expand any rights associated with the property, and any ambiguity shall be interpreted in favor of historically limited use as opposed to expansion of the baseline burden on the neighboring properties. Exactly. The next line would be little letter, I believe, I, which would be discontinuance. If the nonconforming use of the property is discontinued, abandoned, or otherwise ceases pursuant to the provisions of Section 114-3 of the ULDC of Panama City, Florida, the property thereafter shall be subject to, all requirements of the underlying zoning district, and no nonconforming rights shall be deemed to continue. Discontinued or abandoned means the owner intentionally and voluntarily foregoes further nonconforming use of the property. I believe I may have missed one additional section as I'm thinking about, because Lord knows I've spent a lot of time poring over this. There are two sections in here where we define nighttime activities, and to be clear, the nighttime activities are to be from 9:30 p.m. until 8 a.m. So to the extent that I didn't catch one of those, there is that second change. But what you can see here as we move through this document is painstaking and substantive efforts to ensure that we discuss not only what we're going to build on the property, but how we're going to use it, and to make sure that it is used in a manner that is feasible and does not burden our neighbors or the area beyond the baseline which has been established as set forth in this agreement. We believe that this agreement is, again, the fruition of a lot of efforts, and we believe it is due to be approved today. Thank you.
Any questions?
Different questions. My bad.
Any questions for the applicant? Okay. Is there any, anyone else like to speak on this item?
Good afternoon, Meredith Bush, 314 South Balin Street, Suite 108, Pensacola, Florida, 32502. I was sworn, typically we're not in Pensacola because we're attorneys. However, happy to promise to tell the truth. You may recall we were here several times before with concerns regarding the yacht club's intention. I do believe we've reached a point where we are in agreement with the draft as amended by Mr. Nguyen. However, those changes literally were made and finalized as I drove over. So we've been assured that if this is approved by your board and is to go to City Council on the 28th, there will be no additional changes. And if City Council at that time recommends any changes, that it'll be delayed. I'm not available on the 28th. My client, Mr. Hollingsworth, is not available on the 28th. We were promised that it would not be scheduled for appearance before you or the city without full concurrence. That didn't happen, but here we are. We have agreed. I do appreciate the hard work that everyone's put in. I do appreciate the concessions made to protect Mr. Hollingsworth's rights. Happy to take any questions. And again, I think at this point, with the assurance that everything referenced by Mr. Nguyen is in fact what's adopted or presented for final vote, then I think we're good with it. My client is here. I don't know if he wishes to say anything, but again, we're happy to take questions.
Any questions for them? All right, thank you. Is there anyone else here that want to speak on this item? Seeing none, do I have a motion?
Motion to approve.
Second.
Motion second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
Yes.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
I'll abstain.
Got it. Motion passes 4-0.
Thank you. Request letter F.
Request F is case number ending in 0176. It is an application type for a major development. The applicant is requesting to develop an approximate 6,700 square foot recreational clubhouse in the residential 1 R1 zoning district. Any development activity that is not subject to less than minor or minor development review must request major development approval. The owner of the property is St. Andrew Bay Yacht Club and Bunkers Point Educational Foundation Incorporated. Applicant is Robert Carroll. The property is located at 218 Bunkers Cove Road and 212 Bunkers Cove Road.
Thank you. Any questions from the board for staff? Is the applicant here to speak on this item?
Michael Wynn, 203 South Cove Lane, Panama City, Florida, previously sworn in yet again. Again, we are here. This is the, sorry, still thinking about the last one. This is the major development that would be as part and parcel of the agreement that we just discussed. All of the information in the packet remains unchanged, site plan, drawings, renderings, et cetera. Happy to answer any questions about them. But I believe the packet and the information submitted there speaks for itself.
Any questions? Thank you. Is there anyone else here to speak on this item?
And just for the boards, because this is subject to a development agreement, but we do have the major development order, you have two procedural matters going on here. The development agreement, which you just recommended approval to, will go to the city commission for their ultimate approval. The major development order only comes to this board for approval, but they need both in order to proceed. And so I'm going to request that if you find that you will approve the major development order, that it is conditioned upon the city commission approving the development agreement that you just recommended. Okay? So part of your motion would be to, if you so choose, would be to approve the major development order subject to the condition that the city commission approve the development agreement. Okay?
Do you have a motion with the caveat that this is subject to the development agreement being approved by the city on the April 28th meeting?
Yes. Motion to approve conditional of the development agreement being approved by the city commission.
Second motion.
Motion second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
Yes.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
Abstain.
Motion passes 4-0.
Thank you. Requests, letter G? Yeah. Okay.
Request G is case number ending in 1029. It's in a request for a major development. Any development activity that is not subject to less than minor or minor development review must request major development approval. The owner is Watson Bayou Marina Partners, LLC, and the applicant is Mandy O'Regan with Anchor Consulting Engineering and Inspection, Inc., and it's located at 407 Maple Avenue.
Are there any questions for, thank you, are there any questions for, board for staff? All right. Is the applicant here to speak on this item? Thank you.
Seth Chandler, 407 Maple Avenue, and actually live in Tennessee, so do you need that address? I have been sworn in, but, okay.
Any questions for the applicant?
I did put a little packet together for you so you could just sort of get an overview of what we're about.
Yeah, thank you.
It's not, it may not be important, I just wasn't sure if you needed more
nice.
detail. And if you have a boat, we'd like to put it in one of these new slips. We'll give you a special deal. No, we won't. You have to pay full price.
You can't do that.
No questions? Thank you. Is there anyone else here to speak on this item? All right.
We do have our consultant here, the environmental consultant, in case. I don't know if she was here before she was sworn in or not, but, yeah,
Okay.
Bethany.
No other
Sorry.
comments? Do I have a motion?
Motion to approve.
Second.
Motion second, please take roll.
Board Member Anderson.
Yes.
Board Member Cherry.
Yes.
Board Member Barker.
Yes.
Board Member Rich.
Yes.
Chairman Newbauer.
Yes,
Motion passes 5-0.
thank you. No non-actions. This brings us to the audience participation portion of our agenda. Does anyone from the audience wish to participate? Seeing none, meeting's adjourned. Thank you.
I feel